Hello, and welcome to Season 4, Episode 9 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Tarunima Vijra. I'm part of the ARBinBRIEF team and practice international arbitration with Hannity and Vandenberg in Brussels. I have the pleasure of moderating today's episode on navigating arbitrator selections, featuring Erika Stein, an independent arbitrator and founder of Stein Arbitration, who's also based in Brussels, and Khushboo Shahdadpuri, partner at Al-Tamimi & Company, based in Dubai. Erika is an independent arbitrator sitting in commercial and investment arbitrations. Educated in both common and civil law jurisdictions and fluent in 4 languages, Erika sits in cases across sectors and regions. Prior to founding Stein Arbitration, she was a partner with 𝗔𝗥𝗕𝗙𝗏 in Brussels. Welcome, Erika. Khushboo acts as counsel and also sits as arbitrator in international arbitration. Infrastructure, construction, energy, and JV disputes arising out of Middle East projects. She's dual qualified in Singapore and New York. Welcome, Khushboo. You can find further details regarding the practices of Erika and Khushboo in the chat box. Both Erika and Khushboo come with significant experience as counsel and arbitrators, which is apt for our discussion today on navigating the selection process for an arbitrator. In today's episode, we will focus on a key aspect of the selection process, which is the arbitrator selection interview. Parties and counsel often interview potential arbitrators before nomination to assess if the arbitrator would be a right fit for the dispute. These interviews, while valuable for parties, if not conducted carefully, can pose risk to an arbitrator's duty of independence and impartiality. We will explore with our speakers today how to navigate the expectations from counsel during arbitrator interviews, while at the same time maintaining the neutrality and integrity of the arbitration process. So diving into the topic, Erika, I will begin with you. Donning your counsel hat, can you walk us through how you would approach arbitrator interviews? What is the format of the interview, and what are the scenarios in which you would find conducting an interview with a potential arbitrator useful?
Happy to take that on. Thanks, Tarunima. I guess I should probably start by stating the obvious, which is that interviews really are that. Any interviews that I've engaged in as counsel were live oral interviews, usually online, not in person anymore. It is not something that I've ever done, and I've never seen done, where interviews are carried out through written transmission of questions. I think that's probably better both for counsel and arbitrators, just to keep the interviews light, if I can put it that way, and people to be able to answer the questions in a way that they feel most comfortable with. The other thing I would say is who gets interviewed. As ever interviewed co-arbitrators for possible co-arbitrator appointments. I never engaged in any joint interviews, for example, with opposing counsel to try to appoint a sole arbitrator or a presiding arbitrator. And in terms of the co-arbitrator interviews, I would say that I generally wound up engaging in those interviews in one of 4 circumstances. One was when we had many people in mind for a particular case, and maybe some of the people that we had in mind, we had a little bit less personal contact with. So it was good to be able to have interviews with all of those persons in order to be able to really gather a sense of how big our field was in terms of the people that we wanted to consider for appointment in the case. Another time is when perhaps we knew the different candidates, but we didn't know all of the specifics of their experience for a particular case in question. So carrying out interviews enabled us to basically understand better if they had the necessary substantive or sectoral experience. Only very occasionally did I wind up carrying out co-arbitrator appointments just because the client wanted me to do so. There were maybe only 1 or 2 times where the client wanted to be able to sort of report internally that a certain amount of due diligence had been carried out in the selection of the arbitrator process, and they wanted us to be able to interview a candidate in order to be able to ensure or say that that happened. And the last set of circumstances under which I saw that co-arbitrator interviews happened was when we had a very specific clause in a case, and the clause had very specific requirements as to the qualifications of the arbitrator. And so there we carried out interviews to really ensure that whoever it is we were going to appoint did meet all of those criteria. the contours of the format and times when I wound up as counsel interviewing co-arbitrator candidates.
Thanks, Erica. Khushboo, to take this forward, when you're interviewing a potential arbitrator, what key information do you try to glean during the interview?
Thanks, Tarunima, and thank you also to the ARBinBRIEF team for this. So I think the typical questions that we tend to ask prospective arbitrators during these interviews would be the expertise in the subject matter of the dispute, and that's probably the primary and foremost area of interest for all lawyers and clients. But when I say subject matter, I think it's a little bit more nuanced. It's not just the sector per se. So if it's, for example, an infrastructure or construction arbitration, it might be also helpful to sort of deep dive and ask certain questions about the relevant discipline. It could be MEP, piping, civil works, depending on what the scope and the discipline of the dispute. They'll probably feature in the discussion as well. Also, familiarity with the governing law of the contract. I think that's another obvious one. I would even go a step further to the culture of the nominating parties. And I think that's pretty important because every region, every country has a different way that parties transact. So you'd want an arbitrator who sort of understands the nuances and knows a little bit about how the parties would have been transacting in that particular project. The law of the seat, I don't think is the most important aspect, but I think it's a bonus if the prospective arbitrator has that particular expertise or experience. But also, I'd say there are less obvious questions which I think are important to ask, for example, on time availability. So how many cases they're doing as arbitrator, and if they also sit as counsel, how many cases they're doing as counsel. And I think that's increasingly important because in the past, the tendency we had was just to appoint the most senior private practitioners or silks as arbitrators, but we're really spoiled for choices now in terms of the pool of arbitrators that exclusively do arbitrator work instead of independent arbitrators only. So we don't really necessarily just have to keep going back to the tendency in the past of just appointing the most senior silk or partner in a law firm. Also, I would ask the type of arbitrators or the names of arbitrators they're sitting with. I think that's, again, another important aspect because you do want someone that has that gravitas vis-a-vis the presiding arbitrator, and you want somebody who has synergy as well with the co-arbitrators. And by asking these kind of questions, you'd be able to understand his type of cases, how complex they are, just by asking who they're sitting with. When it comes to construction and energy infrastructure disputes, which is what I focus on, there's always going to be certain issues that come up in every dispute. So they crop up quite regularly in the cases I've done for several years. For instance, consolidation provisions, especially due to the downstream and upstream connection in the contracts. So for those, you just got to be really careful how you ask these questions because you do want to avoid discussing the specific facts and or circumstances. You need to be quite generic how you phrase those questions. And I think it's perfectly fine to ask the arbitrator whether they have experience in dealing with these situations or applications, but probably not go any further because you don't really want to reveal anything about the specific facts or circumstances of your particular case, because you might then be breaching certain of the IB or CARB rules, which we'll touch on later. And just really phrase the questions in a way that you're really asking him for his or her experience.
Okay. Thank you, Khushboo. A quick question in this regard for both of you, and maybe I start with you, Khushboo. Is it also common for party representatives to be present during selection interviews with arbitrators?
I think it depends on case to case. But for my cases, for some reason, I have party representatives always present. Sometimes they may not be very talkative. They might not just be there present and take a passive role and happy for us to lead the discussions. But a lot of my clients like to be present. I personally find it quite helpful that they are there in the discussions because somewhere down the line, it could be that the arbitrator makes a decision which is not exactly in favor of what you're looking for. So that way they could see that, the choices that they were involved in selecting the arbitrator had really nothing to do with the application or the decision that was then made against them. I mean, to be fair, this hasn't really happened to me, but I think the most important aspect of having them present during the discussion is that early on, they might then tell us whether they have the same arbitrator in a different cases. And that has happened to me quite a few times where we don't realize that we have a case with the same client who has then another case handled by a different firm, but the same arbitrator has been appointed, either by them as co-arbitrator or a sole arbitrator, and that's in breach of the IB rules, which are really strict now, as long as the same arbitrator is appointed in more than one arbitrations. So as long as it hits 2, that's the threshold, you're already in breach of the IB rules and you need to make a disclosure. So just to avoid anything tactically happening, I think this is, for me, it's quite important and helpful that they're a part of the process.
Okay. Erica, is this your experience as well?
No, it's interesting because I haven't had the experience of having my clients sit in on any arbitrator interviews. Obviously, I've been closely in touch with them with respect to the arbitrator selection process. But generally speaking, they have not asked to sit in on any arbitrator interviews, and it hasn't happened. So this could just be because that's just my personal experience and it's more common than I realize. Perhaps it's clients in particular sectors, perhaps it's clients in particular regions. I don't know, but my experience is a bit different from Khushboo's.
Okay. Well, thank you both for sharing your perspectives as counsel. So switching sides now, Erica, as an arbitrator, how do you approach and prepare for an interview for a potential appointment? So what sort of guidance can you give prospective arbitrators?
So to prepare for an interview, I mean, usually you don't have all that much information, and you shouldn't have too much information because the counsel shouldn't be providing you with anything more than really the basics. But to the extent that you do have some baseline information, I generally just try to, refresh myself on my own CV to check when I've acted in cases, let's say in the same sector or arising out of the same type of contracts, how many times I've done so, perhaps in what kinds of sectors, so that I just almost have my own experience front to mind when I go into the interview, because during the interview, that's really what is up for debate, right? It's what your qualifications are for a particular case. And so you want to be able to go in there and respond honestly about your appropriateness for a given matter. I generally, if I'm going into an interview, I don't necessarily take into account things if I know about them, about the place of arbitration or the whole entire legal framework that may potentially apply to a given case in terms of how I'm going to interact with the lawyers at hand. Generally speaking, what I do is I'm satisfied that my rules allow me to have this kind of a preliminary interview with the counsel, and I know what the general practice is, or generally accepted practice is in international arbitration, that I'm allowed to have sort of an initial ex parte communication with counsel in order to be able for them to assess my availability and my suitability for a case, as long as we don't go into any of the details of the matter. So while I'm in an interview, to the extent that questions start going more towards how I would decide a particular issue, as opposed to what my experience is with a particular issue, I'll just be very honest and I'll just say that I don't feel comfortable answering that. And then otherwise, I just try to be as honest as I can with my answers about my qualifications, because we are in a service business. And if we're going to serve in a case, it's because the party wants to have us for the specific capabilities that we have. And I think it's important to be honest and upfront about what it is that we can bring to the table.
Yeah. Thanks, Erica. Yeah, that's very important. Absolutely. As in, prepare your CV to the best and know your CV. And of course, be mindful of your ethical rules as a lawyer while you're engaging. Khushboo, same question for you. What guidance can you share with prospective arbitrators who are sitting for an arbitrator selection interview?
I mean, I think the CIAB rules are really helpful and should be looked at. And I alluded to this earlier. I mean, Article 3 in particular has a really great provision, which I think starts with matters that should not be discussed, either directly or indirectly. So it talks about specific facts or circumstances of a dispute, or any position or arguments taken by a party, merits of the case, and the views on the merits. So this should be, I think, the sort of starting point and the guidelines that every prospective arbitrator should bring to the table. And if they ask about any of their views on certain matters which could sort of pertain to the merits of the case, as Erica said, just to say, I'm not comfortable answering these questions, and why breach that line if you are sort of really close to it. And another, interesting sort of take on the interview is what are the underlying institutional rules. And again, I agree with Erica. You may not know this before the interview, but if you do happen to sort of ask during the interview and you sort of get an answer, just to be careful that some arbitration rules, and in particular the Singapore International Arbitration Center rules, have a provision that now explicitly disallows the party from engaging with an arbitrator or a prospective arbitrator unless it falls within 3 exceptions. And these are very generic 3 exceptions. So basically, it's unless you're only allowed to speak to an arbitrator or prospective arbitrator if you're discussing, for example, the general nature of the dispute, anticipated proceedings, so very, very generic. You're discussing qualifications, availability, independence, or the suitability for the selection. So apart from these 3 exceptions, you're not even allowed to speak to a prospective arbitrator. So just to sort of be aware that there are rules nowadays that are coming up in latest provisions in the arbitration centers that could disallow you to speak to a party more openly.
That's very helpful. Thank you, Khushboo. We don't have too much time, but I just want to close the loop on our discussion because we've examined selection of arbitrators from the counsel and arbitrators' perspective. And our discussion has been mainly focused on co-arbitrator appointments. So just very quickly, Khushboo, and I'll start with you, Khushboo, as co-arbitrator, if you're in the chair, what are the maybe 2 characteristics that you look for in the chair of the tribunal?
I think it would be somebody who I know is procedurally really competent, because you want the chair to sort of really take charge and be robust and active. And if someone is fairly diverse, I think that would be a big bonus for me, and especially for younger arbitrators. Diversity comes in different forms, and I really like that when they're really thinking about not just a gender diversity, but really jurisdiction diversity, experience diversity. I think these would be the 2 major factors I look at. But overridingly, if the parties have indicated a certain characteristic, like they want maybe a civil court lawyer because they already have 2 common law co-arbitrators, then I would prioritize that and make sure that the presiding arbitrator has that quality or trait.
Okay. And Erica, what about you? What are your most sought after characteristics in a chair?
I agree very much with what Khushboo said. To a large degree, looking for a presiding arbitrator when you're a co-arbitrator is party driven. So the parties have either given you criteria that they want the person to fill, or you are in contact with the party that's appointed you to sort of vet the candidates, which again, looking at the IBA guidelines on party representation or the IBA guidelines on conflicts of interest, this is like one of the small areas that you're allowed to kind of have a direct contact with the party that's appointed you. And so for the most part, it's party driven. And so then in addition to party driven, if I can add something, then I tried to find candidates that indeed I know are procedurally robust, know how to run a case. And I like to try to also bring candidates to the table that maybe the parties wouldn't have thought of. Because as Khushboo said, I think that diversity is something in all senses is something that's only beneficial for all of us.
Yeah, absolutely. Okay, great. Well, thank you both so much for this incredibly insightful discussion and also for sharing your valuable practical insights into the process. Before we conclude, I would just like to thank our partner organizations, ERA Pledge and AAA ICDR Asia Case Management Center for their invaluable support in making Season 4 possible. We are also truly grateful to the many organizations that support the marketing of our series worldwide. For those of you who are watching us over YouTube, our video ends here. Thank you for joining us. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. Comments and feedback. You can register for our next episode on www.arbinbrief.com. We look forward to seeing you there.